Clients often approach us regarding the preparation of a shareholders agreement. Sometimes they've been advised that they need one without fully understanding what it is and why it's important. For more detail on this, you may wish to have a look at our other series of videos on the what if questions we pose to clients to understand their needs and requirements. All companies are required to have a public set of rules, its articles of association, which are filed at Companies House. There's no legal requirement for a separate shareholders agreement, and it can often address similar issues to those found in the articles. So, what is the value of the shareholders agreement?
It often comes down to the fact that a shareholders agreement is an agreement between individuals, between those shareholders in the company at a given time, rather than the articles which are trying to set rules for all shareholders of the company for now, the future, and in any circumstance. This means it's possible to put in rights that are personal to those individuals. It means that you can put commercial issues that you might not want to put in a public document, and that can be really key in certain things that might be confidential, particularly commercially sensitive. The fact you're not filing it at Companies House might make a difference. It also means that you can get much more bespoke and in terms of some of the detail of the operational type provisions and decision making in a way that you simply wouldn't want at Companies House in terms of all of that detail. One of the other real key advantages, and something that you can't do in the articles, is put in place restrictive covenants. Effectively, these are promises by each individual shareholder that they're not going to go and compete with the business, poach staff, or take similar actions that might harm the company. And those you can put in a shareholders agreement that lasts not only while someone holds shares, but also after they don't hold shares for a set period of time thereafter. And that can be something that's really useful and something you just can't do if you only try and put it in the articles.
It's important to look at your articles and any shareholders agreement together to ensure there are no inconsistencies or gaps. It also enables you to make informed decisions about what provisions sit where. And if you have a shareholders agreement in place, the document will only ever capture a moment in time. If circumstances have changed, in particular alterations to the ownership structure, the position may well need to be updated. So it is always best practice to review your arrangements on a regular basis.